Okay, we're live now.
Okay.
All right. So, hello everybody. This is Denise. I was having a little bit of technical issues, but we're live today, and I am so excited to have with me Sabrina Winters. She is an attorney. She focuses on estate planning, and she's here to discuss that with us today. As we all know in the group, that probate is something that can bring a lot of stress, a lot of pain and anguish to family members. And one of the ways to avoid that is by creating an estate plan. So I'm going to let attorney Sabrina Winters explain what that is. And she's going to introduce herself and then she'll go into that.
Well, awesome. Thank you for having me. I appreciate you bringing awareness to estate planning. It is a topic that most people do not want to talk about. You know, who wants to talk about their own death and their illness? But I'm Sabrina Winters. I have been practicing estate planning and probate pretty much my entire career. And that career started in 1998, 99. But originally I didn't want to do estate planning. It wasn't even in my radar. But I had a situation with my uncle that essentially changed the direction of what my practice was going to be like. We were unguided during his passing. He had nothing in writing. My father lived his entire life after that, almost 20 years, wondering if he made the right decisions for him. So I saw what it was like to watch a loved one pass away and not be able to do anything. And then I saw what it was like to settle an estate where there wasn't any will or trust in place. And it was absolutely horrible. So I set up my practice so that I am helping families with estate planning and probate. That is all I do. And it's purposeful. It's meant to be something that we didn't have. Help, guidance, understanding, compassion, education. We lacked all of it. And I just felt, families can't go through this. Like, it was just a horrible event. So that's essentially in a nutshell, that is what I do. I speak on this topic a lot. I'm brought into larger businesses to speak to HR, to speak to hospital staff. I speak to bigger groups, financial advisors, just to educate at every level. There is somebody there that can help you understand that estate planning is important. So that's essentially what I do. I love it.
Okay, all right. So we'll start off with the first question, which is what is an estate plan?
Yes, that is one of the biggest questions. Many people think that an estate plan has to do with, I got to get rid of my stuff. And that's where it starts and that's where it ends. But there's so much more to estate planning. There are, the umbrella is estate planning, and all of the people under there are all of the different aspects of estate planning. So you have a will or a trust to get rid of your things. You have healthcare power of attorney, a living will, a HIPAA form, a financial power of attorney. It should never be piecemealed. So estate planning is, how are you going to plan in writing all of the things that you want to have happen during a time that you have no ability to communicate that? It's a way to keep control over what you want to have happen. My uncle didn't have any of that. None of it. We had absolutely no clue what he wanted. So nobody could speak for him when he wasn't able to make those decisions himself. So the point is, estate planning is the umbrella with all of these different documents and planning strategies, understanding assets and how they're owned, and beneficiary designations, and do I want burial or cremation? Do I want to be kept alive artificially? What if I do? How do I communicate that? And so that's essentially what estate planning is, with all those minutiaes, underneath it. You have to understand your assets, right? You have to understand what you want. You have to understand how you own it. Are there beneficiaries? You have to understand how things are distributed. If you don't organize, you'll never be able to plan, because at the end of that, it's conversations that you have. So it's a lot of steps that many people don't think it's that important, but it is. So it's all
Mhm.
those documents that have to be put in place to get a proper estate plan.
Okay, all right. And one question that, excuse me, I hear a lot is why should I create an estate plan when I don't have that many assets? So some people think if they don't own a house, or if they have a house but maybe they don't have a lot of other things, that they don't really need an estate plan. So what
Mm.
would you say to that?
I would say rethink it, because that's not the case. I always say, whether you're married, divorced, single, you've retired, you're getting ready to retire, you have kids, you have no kids, you're an empty nester, you're healthy, you're not healthy, how big your estate is or how small your estate is, and that doesn't matter. Everybody has a plan that needs to be put in place. It just changes over time. As we get older, our goals, our finances, our wishes, our concerns, they all change over time. The one thing that doesn't change is that somebody at some point is likely going to have to make a medical decision for you. And that, to me, is one of the most important parts of estate planning. So death and illness happens to everybody, whether we're rich or poor. It doesn't discriminate. And because now you understand that that part, medical planning, is such a big part of estate planning, it makes sense why everybody should have it. I can give you an example. It just happened this week, but it happens all the time. Had a client I was talking to. Um, she lost her husband of 20 years. She's going through a hard time, and it's been about a year. And it was a blended family. He had kids, she had a child, but there was real estate that he never added her to. It
Mhm.
is going to be a complete nightmare. And that's the only asset. And it is not valued that much. But the fact that there wasn't anything in writing where an attorney guided them to understand that they would likely have to either change the ownership or in their documents give the wife the house. My guess is that her husband wasn't intending on not having her live in their marital home that they've lived in for 20 years together, that he would want her to continue living there. But
Right.
the way the statutes are, she only owns 1/3 of it, and
Mhm.
2/3 is owned by his kids now. It's a
Right.
horrible situation. And
Mhm.
she's scrambling. Of course, that his kids don't want to have any part of it. They just want the money. And
Yeah.
she needs someplace to live. So
Mhm.
they needed it, and their estate was very small. So
Right.
sometimes, well, more than
Mhm.
sometimes, the smaller the estate, the bigger the problem.
Mhm.
And that's what you need to avoid. And you know, for me personally, it's a gift. Imagine
Mhm.
being able to say, I have to do A, B, C, and D, and that's it. But I know exactly what A, B, C, and D are because this person took the time to write it out for me. Who wants less memory to be anxiety and stress and fear and concern when you could completely remove that from your family's table and be able to allow them to grieve your loss or celebrate it in their own way and not have all of those heartache things that they have to deal with because you didn't do that planning. So
Mhm.
um,
Yeah.
forget about the fact that you think you need to have a large estate or a small estate.
Mhm.
Everybody needs to have a complete estate plan. not a la carte, a complete plan, regardless.
So if I'm understanding you correctly, the estate plan, it doesn't just cover the assets, it also cover like medical decisions and things like that also.
It absolutely,
Okay. Okay.
sitting in a funeral home after somebody dies is horrible. It's just
Mhm.
horrible. There's at least 100 things you have to decide. It feels like it. Casket, cremation, thank you cards, mass cards. What's the reading going to be? Like, there are so many things that have to be planned after somebody passes, that imagine you have something in writing. Your loved ones already know that you wanted cremation, and that you even went the next step to write all of that out for them. Even if you don't pay for it at a funeral home, you write all the decisions out. It's a godsend, and it's a blessing. The more you plan out and the more you set forward something for your family, that the happier that process will be. Now, they're not going to be happy, but the better process is going to be, I'm just going to get this done because I don't have questions. I know what this person wanted, and I'm just going to go do it because they took the time. That's what's
Okay.
important.
All right. So, my next question is, how would, say, the family know if their loved one, if it say it was a parent, how would they know if they created an estate plan? Like if she never mentioned it to them, but she did have one made, how could they find out?
So, my clients don't have that problem because I tell every single one of my clients from the minute we meet through the whole process and up to the end, do not keep it a secret. You have to, after you organized and then after you plan, you have to have the conversations. If you keep this quiet and private and don't tell anybody that you have it, you might as well not have done it because no one's going to know anyway. So you have to have those open conversations. Do you want burial or cremation? What would you do if we couldn't keep you alive in the alive sense? Like, do you want artificial nutrition and hydration? Do you want to continue certain medications and not other medications? Do you want one over the other? Do you want visitors? There are so many questions when somebody is in the process of passing away that have to come up in conversation when you are healthy. And you need to do your estate plans before that event happens. Most of us are not making the best decisions when we are stressed, scared, nervous in an emergency situation. Most of us are not going to make the best decisions. So doing it outside of any of that is going to be the best way, because then you can have these conversations. If you haven't had these conversations, you have to look. You have to look in not just obvious places, the drawer of a desk, in a closet, in the bottom of a closet, in a safe box at the house. But you also have to look under the mattress, under the bed. I had a client who left it in her freezer. I don't really know why, but she told me that's where she was going to keep it, and that's where I told the family they could find it. You have to look in some very odd places because everybody has a different sense of security, a different level of what they feel safe doing. And some people don't feel safe leaving it just randomly in the closet.
Mhm.
So you got to look, and you got to look at weird places. Not often will a will be left for safekeeping at the court's house. I've been doing this for 20 years. I've not had a single client that's come to me that had left it for safekeeping, but there are some reasons for doing that, and there are some people that do it. So always call the court, give the court the decedent's name. You'll call the county where the decedent was living at the time of their passing. If they had moved, you can also check the county that they used to live in, call the court. Um, Unfortunately, if it's in a safe deposit box at the bank and your name isn't on it, then you won't be able to get into that box unless you get a court order. So that's typically the last place that one would be able to find it, because it's the most difficult to access. Sometimes they give them to children. They give it to one child, and they may have multiple children. So it's really, it makes it worse for family when you can't find it. So I just encourage everybody, just have those conversations, have them open. My dad recently passed, and we knew everything because we're a crazy tight family, but we also are not afraid to have conversations that are this hard. And so we always knew what he wanted. Was the decision to stop extreme measures easy? Nope. It wasn't. It wasn't even easier. It was just hard. Was the decision to remove a feeding tube an easy one? Nope. But what my father lived with from his brother was regret. What we're living with is just sadness for losing him. But there isn't any question that we did exactly what my father would have done if he could make that decision himself. And having those open conversations, not just with my mother and he, but his 3 kids. We all talked about it. We all knew. And we all did it when there wasn't an emergency. And that is the best way to plan it out. Don't keep it a secret. Be open about it. Just, it makes it so much more, it gives you the ability to really feel like you did the right thing and that you can move on knowing that you allowed your loved one to pass away with dignity and peace because you did what they wanted. To me, that was an amazing gift my father allowed us to have. And I don't live with regret other than passing. I wish he hadn't, obviously, but I don't regret the decisions I made because he would not have wanted it any other way. And we made it as a family. We all made that decision together. And we had to call hospice in for a consultation. And that was not easy, but we all had it. We all knew what it was going to be like. We all knew what the next steps would look like. But my mother said, my children have to agree. And she was the decision maker. Obviously I had their estate plan done. That would be horrible if I hadn't had them plan. But it was done. And, my mother was obviously the first one to make that decision. And she said, no, I'm not making it unless everybody agrees that that's what Daddy wanted. And of course we did, because, we had these conversations, we knew. And, another thing that people need to be aware of is you have to ask these people that you're thinking of naming if they are willing to do this in the future for you, possibly, because it's also a gift for somebody to say no. Somebody could feel like they can't make that decision no matter how much they knew that that's what you would have done. They can't make that decision. And it's a gift. It's amazing. When I did our plan for my parents, I was last. I said, no, I can't. I cannot do that. I'll be number 3 or 4 on that list. But when the time came and it was important to make it, obviously I stepped up and so did my siblings. So, but we owe it all to the open conversations that we had. Have them. The worst thing is going to happen when you're not here to see it, nor help it.
Yeah, that's true. Okay. So I wanted to ask the question. I know on the probate form, it says that like when you have to do the inventory part and you have to list your assets, and
Mhm.
then there's a section where it asks you to list accounts like with um, joint tenancy with without right of survivorship, and it
Right.
says that like these things may be pulled back in.
Mhm.
Um, of course, is real estate. Then any, like I said, accounts that you have without right of survivorship. So there's a chance, I guess, that those things can be pulled into probate. So if you have a trust, is there still a chance that those things that's listed in the trust could be pulled into probate? Or does that 100% guarantee that it will not be?
So I hate to say 100% guarantee just because somebody has a trust. That's step one. What people do with their assets after they create the trust, that's a whole different story. People who do trusts instead of wills are the clients that say, I want to make it as easy as possible for my family. I want to make the transfer of assets easy. I want to keep them out of court and I want to keep my assets private. Those are the clients where a revocable trust is the perfect fit for them. But it's not a magic wand. You don't create a trust and then all of a sudden it does these magical things. Clients have to take certain steps after they sign to do things. If an asset is owned by a trust, so Sabrina Winters has a revocable trust, and my checking account says the revocable trust is Sabrina Winters. You just avoided probate with my one asset. So
Mhm.
as soon as I die, my trustee technically could step right in and distribute my asset the way I said it should be distributed without filing probate, without getting appointed, and without getting permission from a court because they got permission from me because I gave it to them in my document. So the goal is that you are having open conversations with your client, with your attorney, to find out in your specific situation, what should I do with my assets? Because everybody is different. But what I see a lot is that these trusts are void of any assets because nobody does anything with their trust when they're done. And when you have a trust that's supposed to do really great things for you later, for your family later, but you don't do anything to make that happen, they're still going to probably have to go through probate. So you wasted your money on a trust and now your family's paying a lot of money to a lawyer to help them with that.
So when you say it's void of anything, what do you mean? I always thought that once they created the trust, that's when they had, say, their house or bank accounts and everything, I guess, put into the trust. So are you saying that you can just make a trust and but you haven't included your assets into it yet?
Correct. So when you build a house, you start with the foundation and then the walls and then the roof and then everything inside, right? That's what you're doing with a trust. The trust is the foundation and the structure of the building. But what good is a house if there's no furniture inside and no people living in it? Once the trust is created, you have to go to the bank and ask them to take certain assets out of your name, rename it into the name of your trust, and then you're done. Sometimes you're changing beneficiary designations, sometimes you're changing the ownership. It depends. It's not always across the board that an asset is ultimately owned by the trust. It is based on your particular plan. The goal is that you're avoiding probate because that's the end goal for most people. Now, there's more than one way to skin a cat. You can avoid probate by having your trust own it, but you can also avoid probate by using beneficiary designation forms. So, if I had a life insurance policy and I wanted that to go to my husband, then I would write his name on as the primary beneficiary. He calls the life insurance immediately, probably within a couple of weeks, he gets paperwork, gets a check. It's fairly quick in the realm of death.
Mm-hmm.
So
Mm-hmm.
everybody's plan is going to be different. Not everybody's going to add a lot of assets. Not everybody is going to change beneficiary designations. It just depends on that particular situation and what is needed. But you'll have to do it at the financial institutions, or some of them will allow you to do it online. But that's something that they have to do in order to make their plan work.
Okay. So can you look at it as if the trust is another person and you're giving your assets to that person? So because you're giving it to that person or to the trust, you have to take your name off and put the trust name on. Is that like how it works?
Similar to that. The reason it's going to avoid probate is because it's no longer in my name. Anything that's in my name that doesn't have a beneficiary on it has to go through probate, period. So I want to avoid that. Taking my name off, putting it in the name of my trust is avoiding going to probate. So now my trust, the language dictates who gets what, because I'm writing it. I'm making the rules instead of the government deciding who gets what because I didn't have something in writing.
Okay. All right. So, and I think that was actually one of my questions. So so now I think I see more clearer though. So you would create the trust, and then let's just say 5 years later, you purchased the house. You would want to add that trust. So instead of your name on the trust, on the mortgage or whatever, you would have the trust name, or on the deed, I guess.
On
You
the
would have
deed.
on the deed. You would have the
So
trust name on the deed.
it's a living trust, which means that it's supposed to be there for when you need it to be there. It grows with you. Not that you don't change anything. So, you can amend it as long as you have capacity, but it's created and then you put assets in it. But the assets that go in it are supposed to come out and go to a beneficiary after your passing. And that's what your trustee does. Did I answer your question? I think I went off.
No, you did. You did. So I even see it clearer now. So
You had asked for the deed.
I was thinking that when you create the trust, like when you're sitting down with the attorney, right then you would say, okay, yeah, put my house in this and I want this into that. But you'll create the trust, and then you have to actually go to like the holder and have the name changed.
Correct. You're talking to the attorney about what you ultimately want, where you ultimately want your assets to go. So that does play a part in your planning. But the ultimate action of getting it into your trust or changing the beneficiary, that's something that's on the client's table. Now, you could pay your attorney to prepare all that documentation and everything. Ultimately, you're signing off on yourself. So because it's on the asset, but they got to do something. Just doesn't happen automatically.
Okay. And can you tell us what is the difference between a revocable trust and an irrevocable trust?
So the biggest difference is one, you can't change, and one you can. So the revocable trust that is part of the estate planning is one that I can change whenever I want, just kind of like a will. I can revoke it, I can amend it, I can restate it until the point that I lose capacity. So if I don't know who I am, who my kids are, what my assets are, if I don't meet the level of capacity, I can't change it anymore. But outside of that, I can change it whenever I want. An irrevocable trust, where I have seen it mostly, is when a client wants to Medicare plan and they want to shelter their assets for being used to pay for nursing home care in the future. Now, that trust, once I put my home in there, I have no say in it anymore. Like, I can't control it anymore. If I put my savings account in there, it's not mine to use anymore because you got to leave it in there for a certain period of time before it's protected. So you have to give something up to get a benefit in return. And that's like the 1,000-foot view, really, of what that is. But if I wanted to change it, I can't. Somebody else that's named in that trust can make certain changes, not all of them. And if I need my money from the irrevocable trust, somebody else has to get it out for me and pay for what I wanted it to be paid for. They can't give it back to me. It'll ruin the plan. In a revocable trust, Sabrina can go in there and take whatever she wants. I write checks all the time from my revocable trust. I have a savings account. Nothing's changed. It's still mine. I still own it. It's just named differently because I want an end result that's different when I pass away. And I'll say this, irrevocable trust and Medicaid planning are fantastic, but you have to go to an attorney that does that all day, every day, week after week, because the Medicaid rules change. I think when I was practicing, they could have changed quarterly. I could be wrong. They do change often. And so you really need to know how that trust should be created and what to do. But one, I could change it tomorrow if I wanted to. And nobody can tell me I can't. It's mine and mine alone.
So why would a person even choose the irrevocable one?
When I've practiced in that area, it's retired individuals who now are on a fixed income. And they also are on fixed expenses for the most part. So they know what they're making every month on Social Security or a pension or their required minimum distributions. They know how much money every month they're dipping into their savings, or maybe they're not. But now they have that fear of, oh my gosh, I'm not working anymore. What if I run out of money and I have to go to a nursing home? It's really expensive. I mean, there are some that are $7,500 a month or more for one person.
Yeah.
Many people their money will run out before they pass away. They're outliving their money. So they want to protect their assets so that when that need arises, they've sheltered all these assets in their irrevocable trust, where now Medicaid steps in to pay instead of their assets being used, and they're saving their assets for their kids or their family. That's
okay. All right. And I think the last question that I have is creating an estate plan cheaper than going through probate?
It almost never, ever, ever is more expensive than probate. I have seen $10,000, $15,000 probates for estates that were not large. Probate is through a court system. So there's paperwork, there's filing fees, there's procedures. Normal people don't know all of that. You hire a lawyer to help you. And because of the process being so cumbersome and long and annoying and expensive, that's the reason why people typically are going to do a revocable trust. And if they don't do the revocable trust, they're going to do a will and then take some extra steps to minimize what's happening in probate. The big misconception is, well, if my estate's large, then that legal fee is going to be big. It's not directly related to the size of the estate at all. This one client that I met today, all she has is the home. And it could cost thousands of dollars on how complicated it is for such a small estate. And I will say this, it is always better to put some effort, time, and money towards getting a plan that's done well, that will work, than to let your family figure out, how am I going to pay for it anyway? Because I can't even use your money. I can't get to it yet. Your family's going to be out of pocket. They're not going to know what to do, and they're not going to do anything because of the legal fee or the confusion or the stress or the scare. There shouldn't be a monetary reason not to do it. I mean, think about it. If you own a home, you have no choice but to get homeowners insurance.
Correct.
If you own a vehicle, you have to have motor vehicle insurance. And those are insurances for the what if. What if my house catches on fire? What if I get into a car accident? But we willingly pay hundreds of dollars sometimes every month towards that. Or we spend more time planning a vacation and spending more money on a vacation than many people do, just realizing the importance of estate planning and putting the effort, the time, and the expense towards it. It pays off multiple levels after you pass away. Multiple.
Yeah, yeah. Well, I truly appreciate you coming into the group and answering all the questions. It really helped me, and I know it'll help others. So I really want to say thank you. If somebody wants to reach out to you for a consultation, how can they find you?
Sure. They can reach me through my website, which is simple, sabrinawinterslaw.com. We do have a button there that you can self-schedule yourself. They can always call the office at 704-843-1446. And, we're on all the social media as well. So we're easily accessible. Happy to help. And I should say, the only people that I can help with estate planning are those that are residents of North Carolina. But for probate, I can help families, even if the family that's surviving lives outside of North Carolina. As long as the family that passed away lives in North Carolina, I can assist with that as well.
Okay. All right. That's good to know.
Yeah.
Well, like again, I appreciate you coming on. So I'm going to get ready to sign us out. Okay?
Thank you for having me. I hope somebody got at least one thing out of this that's going to help them make that decision to get their plan done. So I appreciate the opportunity. Thank you.
All right. Thank you.